There's a study making the rounds right now, and you've probably heard about it. Researchers reviewed 80 hospital studies and concluded that nurse practitioners match physicians on safety and patient outcomes. If you're an NP, that probably felt good to hear. You've been saying it for years, right? But here's the uncomfortable part. The board that regulates your license doesn't discipline you based on a metadata analysis. It disciplines you based on a line drawn in North Carolina rules. And that line has almost nothing to do with how good you are. You can do everything right. You can get a great outcome for your patient. The patient can be extremely grateful, and you can still be the subject of a complaint simply because you stepped over a line you may not have realized was actually there. So the real question isn't, can a nurse practitioner do what a doctor does? The real question is, in North Carolina, what are you actually authorized to do? And what happens when you go past it? I'm Nick Dogel, owner and founder of North State Law in Raleigh, North Carolina. We focus our practice on professional licensing, and that includes advanced practice nurses. If you're a nurse practitioner in North Carolina, or you're a physician who serves as a supervising or collaborating physician, this one matters to you directly because the national conversation about NP independence is moving fast. And it's easy to absorb the message that the lines are loosening everywhere. In North Carolina, they have not loosened the way many people assume. And that gap between what people believe and what the rules actually say is exactly where licensing risk lives. I want to walk you through how scope of practice really works here, calmly and clearly, so you can practice with confidence instead of guessing. Let's start with the why. Scope of practice rules exist to give the public a clear, enforceable answer to one question. What is this clinician qualified and authorized to do? The two North Carolina boards involved here, the North Carolina Board of Nursing and the North Carolina Medical Board, share that mission. And for nurse practitioners, they exercise it together through what's called a joint subcommittee. Your authority to practice as an NP runs through both. So why does this feel like it's getting more attention now? That's because physician shortages are real. NP roles are expanding into more settings, and high-profile research keeps fueling a national push towards independent practice. All of that creates pressure, and pressure has a way of nudging clinicians to do a little more than their paperwork actually authorizes, often without realizing it. And here's the core misunderstanding. Many NPs believe their scope is defined by their skill or their experience. I've done this 100 times, so I'm qualified. But in North Carolina, your legal scope is defined by something narrower: your education and national certification, and the terms of your collaborative practice agreement, also known as a CPA. Being capable of doing something is not the same as being authorized to do it. The board cares about authorization. Let's lay out how it actually works in North Carolina. To practice as a nurse practitioner here, you generally need approval to practice from both boards, and you must work under a collaborative practice agreement. That's the CPA. And you got to do that with a primary supervising physician licensed in North Carolina. You can also have a secondary supervising physician as well if you want. This is the part that surprises clinicians coming from other states though. North Carolina is not a full independent practice state for NPs. The collaborative relationship is built into the structure. That CPA isn't a formality you sign once and forget. In general terms, it's supposed to define the drugs, devices, treatments, and procedures you're authorized to provide at your specific site. It has to be reviewed on a regular schedule. There are consultation expectations, especially early in a new collaborative relationship. And critically, the CPA can make your scope more restricted than your certification allows, but it cannot make it broader. The agreement can't hand you authority that your education, certification, and the law didn't already support. So your real enforceable scope is the narrowest of three circles: what your certification covers, what the law allows, and what your CPA authorizes at the site. Live inside that overlap and you're on solid ground. Drift outside of it, and that's where the risk begins. Here's a hypothetical to make it concrete. Again, not a real client, just an ordinary situation. David is a family nurse practitioner at a busy clinic. His supervising physician is out for 2 weeks, and the backup arrangement is thin, to say the least. A patient comes in with a complex issue that's really a little outside David's usual lane, but he's confident he can manage it. And frankly, the patient can't easily get an appointment elsewhere. So he handles it himself, orders, prescribes, summarize the whole visit without looping in a physician. The outcome ends up being fine. The patient does well. David feels good about it. But look at what happened structurally. David made a clinical decision in an area that arguably sat outside his population focus and his CPA during a period when his required collaboration was weak and he didn't document a consultation or escalate it. If that visit ever gets reviewed by an insurer, by a colleague, by the patient's next provider, the good outcome won't be the headline. The headline will be that he practiced outside his authorized scope without the required collaboration. Good intentions, good result, and still a real exposure, because the rule isn't measuring the outcome, it's measuring the authorization. So how does this turn into an actual licensing problem? It rarely starts as, quote, you exceeded your scope. It usually starts as something else. You get a billing audit, a patient complaint about something unrelated, a records request, a dispute between a clinician and a practice. And then in the course of that review, someone looks at the chart and notices that the care provided doesn't exactly line up with what the CPA authorized, or that the supervising physician relationship wasn't being maintained the way the rules contemplate. Now you have a scope issue layered on top of whatever the original question was. And because NPs are regulated through both boards, these questions can implicate the supervising physician as well, which means a single chart can create exposure for two licensees at once. That's part of what makes scope issues escalate quietly. They're often discovered while everyone is looking at something else entirely. This is where most clinicians get into trouble, and it's almost never the original clinical decision. It's what surrounds it. The first mistake is letting the CPA go stale. The agreement sits in a drawer, the supervising physician changes jobs, the review date passes, the practice site shifts, and the document no longer reflects reality. When that gap is discovered, it's discovered all at once. The second mistake is fixing records after notice. When a clinician senses a scope question coming, the urge is to go back and add a note documenting a consultation that maybe should have happened, or to adjust the record so it lines up better. This is the one of the most damaging things you can do. The moment a regulator believes a record was altered after the fact and is fraudulent, the conversation stops being about scope and becomes a conversation about your honesty. And that is a much harder place to defend. The third mistake is over-explaining when first contacted. Talking at length without preparation to justify a clinical decision tends to expand the inquiry rather than close it. And the fourth is treating collaboration as paperwork instead of practice, assuming that because the physician's signature is on file, the actual consultation and oversight don't need to happen in real time. The rules care about the relationship, not just the signature. So, what is in your control? Generally speaking, the most protective mindset is to know your three circles cold: your certification, the law, and your current CPA, and to treat the narrowest one as your real boundary. When a situation pushes you towards the edge of it, that's the signal to consult, refer, or escalate, not to stretch it out. What we often recommend in a general sense is keeping your CPA genuinely current, treating the review dates and the supervising physician arrangements as live obligations rather than filing cabinet history. A CPA that actually matches your practice is one of the strongest protections you have, and that is entirely within your control. In many cases, the best decision is made before you say anything at all. If you ever receive notice that your scope or your collaboration is being questioned, the time before your response is the time that matters the most. Preparation in that window does more good than any explanation offered in the heat of the moment. And none of this is an argument that NPs aren't capable. The research you're hearing about may well be right about outcomes. The point is narrower and more practical. In North Carolina, capability and authorization are two different things, and your license is covered by the second one. So, can a nurse practitioner do what a doctor does? Clinically, in many situations, the evidence says the outcomes can be comparable. But legally, in North Carolina, your authority is defined by your certification, the law, and your collaborative practice agreement. And stepping past that line is what creates risk, even when the patient does well. The takeaway: let your authorization, not your confidence, define the edge of your practice, and keep the agreement that sets that edge genuinely up to date. This doesn't mean the system distrusts nurse practitioners. It means the rules are precise, and precision is unforgiven when a chart gets reviewed. If you've received any indication that your scope of practice or your CPA is being questioned, the most useful step is to get clear, informed guidance before you respond, not after you've already explained yourself. And if you you'd like more on these how to do videos and see how this plays out, take a look at a companion video on this channel about staffing pressure and your nursing license. Thank you for taking care of North Carolina so much. We appreciate it. This video is general educational information about professional licensing in North Carolina. It is not legal advice. It does not create an attorney-client relationship, and every clinician's situation is different. Nothing here predicts the outcome of any particular matter.